Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, arbitration, collaborative law, restorative justice, negotiation, conciliation, ombuds, adjudication, and of course, early neutral evaluation. My name is DrChinweEgbunike, postdoctoral fellow at the University of Brighton and the fellow of the American Bar Association, section of dispute resolution. I'm delighted to welcome Professor Kristen Blankley to the EVA show. She is the president of the Global Collaborative Law Council, Incorporated, a professor of law at the University of Nebraska, and an adjunct affiliated professor at Mitchell Hamline School of Law. Professor Kristen researches on alternative dispute resolution, legal ethics, and the intersection of ethics and dispute resolution. She also teaches ADR, family mediation, and mediation. She's involved in ADR policy within Nebraska, as well as nationwide initiatives. She was appointed a member of the American Bar Association MBA section of Dispute Resolution Council in 2016 and chairs the section on ethics. She has been involved in developing ethics policies and standards in the areas of mediation and restorative justice. Professor Kristen wears many hats, so I've left the links to her profile below. Welcome to the show.
Thank you. Thank you.
Let me start sharing. It's such an honor to have you on the show. So without further ado, the first question is, what is collaborative law and its impact so far in the US?
So collaborative law it's a really innovative negotiation-only style of dispute resolution. It is attributed to a Minnesota lawyer named Stu Webb, who created this idea in the 1990s when he was just noticing how acrimonious litigation could be, especially in the area of domestic relations. And so he said, what if we had two parties and those two parties had two lawyers, and those four people work together in a problem-solving way, and in order to help ensure that they work in a problem-solving way, at the beginning, they decide that if the negotiations do not work out, that those lawyers would withdraw from the case, and the clients would have to get new lawyers to go to litigation. And so what this does is it frees up those collaborative lawyers to be able to focus on problem solving only. The traditional lawyer has to think about, okay, well, I've got to think about settlement over here, but I also have to think about litigation over here. And so Stu Webb said, if we just take away the possibility of litigation, let's see what that does. And so that really is the idea of collaborative law, that we have clients who are represented by lawyers, that those lawyers agree that they are not going to be lawyers who take the case to court. It opens them up to be able to engage in problem solving. And it's a revolutionary type of practice that requires what we sometimes refer to as a paradigm shift. By focusing solely on negotiation and problem solving without kind of having that, well, what if in the background.
Oh, okay, thank you so very much. So you've touched on the history behind collaborative law. So is there any measurable difference or impact on the cost and time frame for settling disputes or conflicts via collaborative law when compared to litigation or mediation? Yeah, sorry, carry on.
No. And it's actually a really controversial question that you're asking, right? Does it save time and money? And it's hard to determine that because we have to figure out what we're comparing it to. And so there have been some studies to show that collaborative law can reduce the time and the expense of litigation because you don't have a trial. The other place where collaborative law can really reduce time and cost has to do with discovery. And so in the United States, so much of the legal fees are paid in that discovery process, right? The fighting over documents, taking depositions, all of that sort of stuff. The collaborative lawyers don't engage in that. They don't do depositions. They freely agree at the beginning through the use of a participation agreement to exchange the relevant documents, that that they're not going to fight over which documents are produced. You don't have to ask for documents. Everybody just shares their information. And so that portion of information sharing, that discovery portion, you can really save a lot of money if you freely exchange the documents that matter. On the other hand, the collaborative process requires significant amount of lawyer time during what we call like four-way conversations. And so the collaborative process often takes it's not like mediation, where mediation you kind of show up and you spend a half a day or a day mediating. The collaborative process takes longer, and it's usually a series of meetings that could last 2 to 4 hours with breaks in between. So the collaborative process it's going to be a process that takes months. It's not going to be a process that takes years, but it's also, unlike mediation that can take one session, the collaborative process can take multiple sessions.
Oh, okay. So I was asking about the similarities and differences between collaborative law and mediation. Is there, because you touched on the similarities and differences as well. Is there still any similarities left?
No, absolutely. And I do think that there are significant similarities and there are significant differences between collaborative law and the mediation process. And so the mediation process is going to involve a mediator who is going to be that third party. The collaborative process can include a mediator or a facilitator. It absolutely can include kind of, in addition to those four-way meetings, 2 lawyers, 2 clients, you can also have a facilitator. We haven't yet talked about some of the other people that might be involved in the collaborative process, including kind of neutral experts, like neutral financial experts, or coaches, or other types of people who really help to maintain that problem solving, that work of problem solving. Mediation, on the other hand, involves the parties and it involves the mediator. Lawyers may or may not come to a mediation. Most lawyers go to mediations in the civil realm. In the world of family law, that's going to vary from place to place, whether lawyers attend mediation with the clients. One thing that's very different in mediation compared to collaborative law is that at least the trend in the United States for mediation is that the parties don't always sit in the same room together or have what we call a joint session. And in fact, many mediators use a shuttle style or a caucus style of mediation. And so the mediator spends time with one side and then the other side. We wouldn't do that in collaborative law. In collaborative law, like everybody is going to, the idea is that they're all going to be together and they're all going to be together working on the problem. And so certainly a mediator can be involved and facilitate, but the process will probably look a little different because in collaborative law, it's like really crucial that everybody be working together, kind of in the same room together on the problem together. The other thing that is similar is that the idea of problem solving, though, is the same. And so mediators are looking to solve problems. Collaborative lawyers are looking to solve problems both of them are looking kind of in a collaborative way rather than an adversarial way. So they certainly have that in common, but some of these other pieces are definitely different.
Oh, thank you so very much. So can it be used to settle all kinds of cases?
Yes. No, it's
Okay.
Yeah. So collaborative law in the United States probably has its strongest roots, as well as its most robust practice in the area of domestic relations.
Okay.
And so in the United States, we're going to see a lot of collaborative lawyers who talk about collaborative divorce. And there are a lot of reasons, especially if children are involved, but even if children aren't involved, why collaborative law makes sense in areas with relationships, because and for the same reasons we want to use mediation, is that we want to preserve relationships as much as possible, and the collaborative process has at the at the core the idea that that these are parties who are going to work together, and so for people who need to parent together in some way, shape, or form for the rest of their lives, it does make sense. That said, that the collaborative process doesn't have to be limited to cases involving domestic relations. And there are other places, particularly areas with relationships, that might make sense for the collaborative process. If there are issues involving kind of closely held companies, whether those be family businesses or not family businesses, people that have these relationships, where the relationships are important. We can talk about the collaborative process in estate planning. We can talk about the collaborative process. And so the process itself could be used for any type of dispute, but I think it's best suited for disputes where the parties know each other and can work together in a way that, and where the parties want to work together in a way that could help preserve their relationships.
Okay, thank you so very much. So can it be utilized in all cities in the US? Collaborative law?
No, and that's so the biggest difficulty, I think, for the collaborative process is that everybody involved in the process needs to buy into it. And so not only do the two clients have to agree, or the two or more clients have to agree, because imagine we're talking about a small family business. We might have 4 siblings who are all owners of a family business. So now you need 4 siblings to agree, not just 2 people to agree, but we need 4 to agree. And we need all of their lawyers to agree. And their lawyers also, not only do they need to agree, they also need to understand what the collaborative process is. And so that requires training. And so what usually ends up happening is that in jurisdictions, like in localities across the United States, usually in bigger cities, there will be practice groups of lawyers who are all trained in collaborative law. And then if they have cases where that look to be good candidates for the collaborative process, they can they can talk to their client about having the other clients involved, have them find collaborative lawyers as well. And so because all of the lawyers must be, they must understand collaborative law, they must understand the process, and some jurisdictions require that they be collaboratively trained, it can be difficult to convince everybody that this is the route to go. And so in rural areas, this can be particularly difficult if training hasn't been available. And this is, I think, one of the biggest frustrations of collaborative lawyers is that they see cases and they think, wow, this would be a really great case to have as a collaborative case, but that lawyer on the other side wouldn't be interested in it, or the other party wouldn't be interested in it.
Okay, thank you. So can okay, I've heard people using collaborative law and collaborative law practice. Is there any difference between the two?
Right. And so when we use the term collaborative practice or collaborative practices, we're broadening the scope of what we're talking about. Collaborative law really is this process where we have clients who retain collaborative lawyers. And so so the presence of those lawyers, those collaborative lawyers, I think is an essential element of collaborative law. Now, collaborative practice might involve other types of professionals that engage in similar and complementary work. And so I have seen as a collaborative practice the use of one neutral, whether that be a neutral mediator who's also a mental health practitioner, who does a mediation style that looks like collaborative law, but you don't necessarily have the attorneys. And or the use of mental health professionals and coaches, but without the use of attorneys or the use of kind of a single collaborative financial neutral. And so collaborative practice can be similar where you are engaging in problem solving by looking at interests and goals, by following kind of a set agenda and other items, but you don't necessarily, but when lawyers are not used. And then the focus then on collaborative practice might be less focused on legal issues. It might be more focused on business issues or relational issues. But when we use the word collaborative practice, it means that we're going to expand the participants and maybe even kind of what that process looks like.
Oh, okay, thank you so very much. So what are the advantages and maybe disadvantages associated with collaborative law?
Yeah, so collaborative law is it's useful for, again, preserving relationships. Because I mean, you can imagine that a divorce is going to be stressful no matter, I mean, even the best of divorces is going to be stressful in some way, shape, or form. And so collaborative law can reduce the amount of conflict and can reduce the tension. And for some people, that's really important. That litigation and solving problems is a difficult and stressful thing to do. The collaborative process is intended to be more civil, to be less stressful, and to be more creative. And so those are some real advantages to the collaborative process. The collaborative process, research has shown, is successful. And so most cases that use the collaborative process, and most research shows that more than 90% of cases that use the collaborative process end with an agreement. Some of the big downsides of collaborative law, however, is that it's not guaranteed. And if the collaborative process fails, then the clients have to start over. And so that can be extraordinarily costly if the clients have to start over. If the clients don't trust each other to be able to provide, I mentioned earlier that the collaborative process really, the parties agree to provide information without hiding information. And so if in fact the parties don't trust each other to participate, then the collaborative process might not work. The collaborative process potentially has some abuses if parties or attorneys are hiding information, if they're not being truthful. And so the collaborative process requires some vigilance on the part of the attorneys. And attorneys sometimes have to have really difficult conversations with their clients about things like, okay, you're going to have to disclose this. You're going to have to mention these financial things. We can't keep secrets in this process. That's not what we signed up for. And so there are certainly kind of dangers of abuse because the model is set up as one that has open communication and open information exchange.
Oh, thank you so very much. So that reminds me, what models can be used in collaborative law?
Right, and so the model itself, and many components, I mentioned many components of the model, but it really is based on what we refer to as like these four-way conversations, which and at its core is a four-way conversation that we have, two parties and two lawyers, and they sit down and they have sessions where everybody participates. And this is different than in a lot of traditional law practice, where the lawyers might speak to one another or the clients might speak to one another, but not together as a group. And so this puts everybody together in the same room. Prior to those meetings, the parties everybody's got to be ready to participate. So preparation is an important part of collaborative law, that you're ready for those meetings, that you have created an agenda. Maybe that the parties have gone and are engaging in some counseling with mental health practitioners. Maybe they're working with financial neutrals in order to have financial information ready to talk about. And in the context of domestic relations, maybe working with child specialists so that the children have a voice, either actually have a voice, or through mental health practitioners or child specialists who can report to the parents what's going to be important for them. So there's a lot of work that has to happen going into those meetings. And then there's work that has to happen in between meetings, after a meeting. So in those meetings, there's going to be an agenda. Someone's going to have to make sure those meetings are led. Someone's going to have to take notes after the meeting. Those notes are going to have to be transcribed into minutes, and then you're going to need to prepare for the next meeting. And so there's a lot of work that goes into the collaborative model.
Oh, okay, thank you so very much. So what is your advice for potential users and people pursuing a career in collaborative law?
Yeah, so my advice is that it's an extraordinarily successful process when the parties take it seriously, but that this is a process that the parties are going to be involved in. And so this isn't just kind of turning something over to your lawyer and checking in occasionally, right? There is work that needs to be done, not only by the lawyers, but also by the client. And so if the client isn't ready to participate, then collaborative law might not be the right process for them. And so my advice is to know that the process can work, and that if you sign up for collaborative law, to put in, to prepare with your lawyer, to work with the other professionals on the team in a way to set up that for success, and then to be open and honest, and to be open to possibilities for settlement and resolution that maybe they hadn't thought about, and to kind of be fully present in order to try to turn the situation into to make that into something that is, a best case scenario for everybody. And if there are kids, to make it to keep them involved. If it's a family business, to kind of continue to think about, right, employees and the entity and vendors. And so how can that process be used to turn a bad situation and make it better?
Oh, okay, thank you so very much. So final question is, what is the future of international legal research via podcasts, and particularly in ADR, or in this case, collaborative law?
Yeah, and it's great that you're doing these, and these are so informative and helpful, to be able to find ways to promote various aspects of alternative dispute resolution. And certainly it doesn't matter kind of where you are or what culture you live in. There is conflict. There is going to be conflict. And so I think it's important to understand how other people deal with conflict. And this collaborative law piece that I'm talking about, from the US perspective. And there might be aspects of collaborative law that really make sense in other places, but some aspects of it that might not be. And so I think to the extent that we are engaged in cross-cultural conversations and cross-cultural education, it's helpful to listen, and it's helpful, but to know that the U.S. model of collaborative law might, it might not fit 100% other places, because we need to be sensitive to cultural considerations everywhere. So I think it's really useful to learn about how dispute resolution is being done in other places, but we also need to think about how to adapt it to the local culture. And so, so thank you for kind of taking the lead and trying to kind of capture what people are doing in different places, and that's an important first step.
Oh, thank you so very much, Prof, for your insights and perspective and learning that you shared with us today. And I believe that potential users would embrace or will embrace all you have stated here in and opt for ADR whenever the need arises, particularly collaborative law. Thank you for coming on the show. This is a masterclass. Thanks very much.
Thank you for having me.
All right, cheers. Bye-bye. Take care.